VPLC advocacy work at the General Assembly, we have been involved in a number of different conversations with different housing stakeholders since pretty much the day that Governor Northam issued the state of emergency order back in the middle of March. And things have been changing very rapidly, as you all know. We have been very grateful to have, obviously, the support of everybody at the Poverty Law Center and all the legal aid attorneys across the state, but also to be able to work with this administration and with others across the state who care deeply about the rights of tenants, as I'm sure all of you do. Tony, did you want me to share anything else? I know that people are anxious to get into the meat of tonight's presentation, and I know that Phil, I think, is going to guide us through the different slides, and here we go. Great. And what you see there is a statement of our mission, but even more importantly, the vision that we have that, again, I know those of you who I know who are on this call, and that's almost most of you, share our vision that all people in Virginia will ultimately have equal opportunity to succeed and equal access to justice. And so everything that we do, and I'll say especially everything we do in the area of tenants' rights, because that's what I've been working in for the past 10 years, is really geared toward leveling the playing field. Okay, next slide, please. This is just a lovely slide that shows the structure of the Virginia Poverty Law Center. We are divided up into 3 areas, and everything we do fits into one of those centers. So we have a Center for Family Advocacy, and we have attorneys there who specialize in domestic and sexual violence, protecting both folks who are immigrants who have experienced domestic and sexual violence, as well as others. We also have attorneys who specialize in family law and child welfare law in that center. In the Center for Healthy Communities, we have our healthcare experts, who many of you know, as well as experts in various public benefits, including SNAP and TANF. And then our Center for Economic Justice spans a lot of different substantive areas, including consumer rights, rights regarding utilities, student loan issues, and of course housing. And I'm sure I've left something out, so my apologies to the many things that people in the different centers do that I didn't mention. I think we all know that Virginia, like most of the country, is experiencing what many have come to call an eviction crisis. It was just about 2 years ago, here we go, a little over 2 years ago, that this story hit the front page of the New York Times. And I think fairly suddenly, the rest of the country knew what Phil and Tony and I have known throughout our legal aid careers, which is that there are a lot of tenants who get evicted in the Commonwealth of Virginia. And more than that, there are incredibly complex causes of evictions and incredibly grave consequences. I'm sure most of you are familiar with Professor Matthew Desmond, who wrote the book Evicted and also started the Eviction Lab project. And I know that I have heard him say eviction is both a cause of poverty and a result of poverty. And I think the lack of affordable housing is certainly one of the things that leads to eviction. I think that is, in many cases, poverty itself is causing folks to pay too much for their rent. I was looking at statistics just yesterday, recently put together by the University of California at Berkeley on the current crisis. And it talked about the fact that over 200,000 renters in Virginia and I think it's probably more than that. I think it's something like 40% of the renters in Virginia, which is far more than 200,000, are housing stressed, meaning they pay more than 30% of their income for rent and utilities. So that is definitely one of the causes. There aren't enough tenants attorneys. This is something that honestly I have worried about every single day since the COVID-19 crisis started. We know that people cannot pay their rent. We know that so far we have not seen enough assistance, financial assistance from the federal government to enable all of these people who have been laid off because of COVID-19 to pay their rent. And as a result of this, there are going to be tens of thousands of folks facing eviction once the judicial emergency ends, and we simply do not have enough attorneys to represent all of these folks. We haven't had enough legal aid attorneys for as long as I've been a legal aid attorney, and that's been more than 25 years. We know that there are far too many tenants who have to go to court, who have had to go to court without attorneys, and we know what a big difference that makes. And so we know we don't have enough attorneys. Without an attorney in an eviction case, a tenant is 1/3 more likely to actually get evicted. It makes a big difference. And finally, particularly up until 2 years ago, I think the Virginia laws definitely favored landlords over tenants. We have seen some great progress in the past 2 years, and I am hoping that that progress is going to continue over the next few years. If there is time at the end of the presentation tonight and at the end of the Q&A session, I was hoping to share with you all my vision, my slate of things that legislative changes that the COVID-19 crisis has made me painfully aware that we need here in Virginia still. So yes, our laws have become more balanced, but I think they are still favor landlords, and I'd like to see some more changes. But first, we'll get to the rest of the presentation. And this is Phil Storey, who you're going to hear from next, put this slide together. And these are great slides and really kind of super scary, right? And that's what tenants are feeling right now. It was already difficult to be a tenant when you were paying 40 or 50% of your income toward rent, living paycheck to paycheck, possibly paying your rent late and having late fees on top of that. But then adding to that, this COVID-19 crisis, the fact that you're out, you may have lost your job, or your hours may have been reduced, or you may rely in part on income from spousal support or child support to pay your rent, and your provider of that support has lost his or her job. Now, not only is there a real possibility that you may be evicted because you can't pay your rent, but getting evicted means you're also getting exposed to this virus. You can't shelter in place. Going back to what Professor Desmond said about evictions being both caused by poverty and the cause of poverty, I think this slide, which mentions tenant screening companies and talks about the downward housing spiral, really is talking about what happens when you are late on your rent. Let's take someone who always paid on time, someone who had a job, who was, making ends meet, living paycheck to paycheck, and lost their job because of COVID-19. By the time they get a job again, they've got late fees. They perhaps can't stick with the payment plan. They get evicted. They now have an eviction on their record. When they go to get a new place to live, they are far more limited in their options, because we know that most landlords use these third-party tenant screening companies to check for credit history, for eviction history, for other criminal records and whatnot. So losing your job, having bad credit because you lost your job, getting evicted because you didn't have any income, all adds up, leads you to perhaps living in a hotel or motel because that's the only place you can go. Now you're paying even more for a place that is probably much lower quality, and you can see how that can spiral down.
So, and I'm going to jump in here, Christie. So the other thing about this downward spiral is it's just very expensive. Eviction is very expensive in a lot of different ways. As people, I'm sure, understand, you can, if you're a tenant, you can be liable for your landlord's attorney's fees, their filing fees with the court, for whatever late fees and post-judgment interest on that. You might have to move your kid to a different school, and you lose your transportation because you were on the bus line that took you to work. You might lose your job because you had to miss work too many days to find a new place to live. You can see lapses in, for instance, Medicaid coverage for your kids when DSS sends the renewal information to an old address. All kinds of things, bad things can happen as a result of an eviction, and that's why, as Desmond points out, eviction is a cause and not just an effect of poverty. So I'm gonna talk a little bit about, at this point, about what eviction looks like, what this crisis looks like in Virginia. So it looks like, I got ahead of myself here, it looks like a single mom of two teenagers whose landlord decides he wants them out, and he harasses her to the point where she loses her job because he's forcing her to leave work to deal with fake emergencies. This is an actual call that we had on the Eviction Legal Helpline of a client in far southwest Virginia. So it also looks like a senior citizen who takes care of her disabled adult son and has been living in an extended stay motel for more than a year, when her income falls off, and the manager illegally changes the key code on orders from the corporate office without going through the required court process. It looks like a gentleman who lost work because of the pandemic, and when he couldn't pay rent, his landlord cut off the electricity to his apartment, even though he relies on an electric nebulizer to treat his asthma. It looks like a family whose income from driving truck dried up because of the pandemic. And so the landlord cut off the water to their mobile home and threatened to light the truck on fire if they didn't pay or move out immediately. Unfortunately, all of those are actual cases that have come to the helpline, and it looks like hundreds of thousands of other situations just like those every year in Virginia. So every year in Virginia, the cases that actually make it to court there's over 150,000 a year in Virginia. Many of these cases that we just mentioned haven't made it to court. Who knows if they will make it to court? So the crisis looks like those kinds of things and all kinds of other things. And so in response to the crisis that didn't just start with COVID-19, there were a lot of things put into place, as Christie mentioned. The article from the New York Times kind of shamed Virginia into acknowledging the problem and addressing it with legislative focus and new laws, with some innovative programs like eviction diversion pilot programs in 4 different areas of the state, with some funding for additional legal aid lawyers and other things. And one of the things that we started up then about 1.5 years ago was the Eviction Legal Helpline, which is a service for people who are facing potential eviction to call statewide. They can give us a call, and we have volunteers in order to address the scale of the need. It's designed to be run by volunteers remotely, and attorneys and non-attorneys that can work from home or from their office, but they'll take the calls or return the calls, get the information, give someone advice based on training that we have and support that we offer. And then VPLC, we will follow up on cases that need to be followed up on, hopefully referred to a local legal aid. If somebody has a good defense, they just need a lawyer to help them present that defense. And so far, about close to 20% of the cases that have come through the helpline, they have had a defense to eviction, and we've been able to refer them to the local legal aids. So this is a new model because there are lots of legal helplines in the country. Almost all of the legal helplines in the country are staffed by professional staff. It is very difficult depending on the topic, the legal topic. So a senior legal helpline, somebody might call with 100 different questions, right? That range from public benefits to family law to estate planning to all kinds of things. You can't prepare a volunteer attorney who's not a specialist in that to answer those calls. With evictions, it's a narrow legal issue, and it's something that we can. There are few enough moving parts that we can train attorneys to give competent legal advice with our supervision to these people. So this is a very new model, and it's something that we're pioneering here, and so far it's really helping a lot of people. So those people, the folks who are out there who are facing potential eviction, call us at any point in that process. And it might come before step one here on your screen, where a landlord just tells somebody, I'm not going to renew your lease next month, you better plan to move out. They can call us and we can explain to them, here's the process that here's what the landlord's rights are, what your rights are, and what the process is. And people call us, I've had people call me, unfortunately, moments before the sheriff shows up to evict them. But at any point in this process of an eviction process, folks can call the legal aid helpline, the eviction legal helpline, and we can give them accurate information and advice so that they can make good decisions based on correct information and not, bad decisions based on information that they get from some other source. So we have right now, what we're seeing is that we've got some things going on that are helping tenants in this kind of a situation because of the crisis. One of them, there's a judicial emergency that's been declared, which Christie mentioned, and that has been extended currently until at least May 18th, but no non-emergency hearings are taking place, which means no cases for eviction are being heard. Landlords can still file the paperwork for eviction, but they're not getting a hearing scheduled until at least after May 18th, and very possibly it will be extended beyond that. But so that's one of the relief measures that we're seeing on a state level. Now, on the federal level, in late March, the Congress passed and the president signed the Federal CARES Act, and that one of the provisions of that includes an eviction moratorium. And under the provisions of that, if a tenant lives in a covered property, which means a property that in some way participates in federal, has some kind of a federal support or federal guarantee or insurance or something like that. So whether it's a mortgage with Fannie Mae or Freddie Mac, whether it's a mortgage insurance program, if they accept Section 8 vouchers, public housing, all of that kind of stuff, then they should not be able to file to evict somebody based on non-payment of rent until at least August 25th. So those are good, very good protections, but a tenant has to be in a covered property, and it's not. It can be a little bit difficult to figure out if a tenant is in a covered property, but those are really important protections right now. So what happens after these protections run out? Well, we and you and other advocates are working with policymakers to try and address that and provide additional protections. But we know that a tidal wave of evictions is coming down the pike. So when that dam breaks, when those protections are over, there will be many tens of thousands of eviction cases brought. And it'll be extremely important at that time that folks get more than ever, that folks get competent legal advice and ideally representation, because there are going to be a lot of unusual defenses that are based on, say, the CARES Act, other emergency measures, new notice requirements that are in Virginia law that become effective, and things like that that are going to provide defenses. And so really legal representation is going to be critical to meeting the demand for people who are going to be facing eviction at that time. So those are some of the things that we're facing right now, and things that have folks like Christie and myself and other advocates lying awake at night, worrying about so many of our neighbors who are in this really difficult situation. So that's sort of the context that we're in right now, and what we see on the horizon. Christie, do you have anything to add to that?
No, Phil, I think you covered it really, really well. I will only say that we need to sort of face this tsunami with every piece of equipment we have in our toolbox, right? So the Eviction Helpline is an incredibly important piece of equipment, since it is the very first, it's really the front line for tenants all across the Commonwealth. And it is the front line and available to tenants facing eviction, regardless of their income level. While we may not be able to refer a tenant who makes too much money for legal aid, Phil and his group of volunteers can give them invaluable advice about their situation that can really make the difference between them maintaining housing and them becoming homeless.
So we can take questions now. If folks have questions, if you could raise your hand, and the way you raise your hand is if you can find where it says manage participants, or it says participants, and you can click on that, and one of the options for you is to raise your hand if you have a question, and then Tony will unmute you so it doesn't become a free-for-all.
Okay, so
okay.
So what I'll do is go ahead and unmute Michelle Saka. Oh, I hope I'm saying that correctly.
Oh,
Go ahead, Michelle.
greetings, everybody. I had a question. Oh, I put my hand up because I thought my chat wasn't working. That was why that was. But I had a question. I was wondering if you all were aware of the Richmond Public Housing Authority put out a letter telling the residents that they have to pay tomorrow, and they have to sign something. And I was wondering if anyone, if anybody was giving any assistance to the residents on that issue.
I have not, this is Christie, I have not heard about that. I'm furiously trying to write down what you just said to me. We have been in conversation with leadership at RRHA, with their attorney, and so we expect to have a conversation with him in the next few days. I can tell you that all of RRHA property is covered by the Federal CARES Act, and so they are subject to that eviction moratorium. There was already an eviction freeze in place because they were, as many people know, having some difficulties figuring out some of the accounting issues that they had, and they had agreed to a freeze through the end of May. Well, of course, the CARES Act now extends that freeze. As Phil pointed out, public housing residents and other residents living in federally subsidized housing under the CARES Act are protected from eviction really until the end of August. Until July 26th, the Public Housing Authority cannot charge any late fees, and they can't take any action to evict anyone. Now, the CARES Act doesn't say that they're not allowed to collect rent. So if what they have done is simply said, hey, your rent is due, or issued an accounting as to how much is due, that doesn't violate anything in the CARES Act. except that they are not supposed to send any termination notices. So if it says pay the rent or we will evict you, then there's a good chance that that does violate the CARES Act. So I'm glad you brought this up, and we will look into it. Thank you.
We have a caller on the line, Marty Wedbright. If you'd like to unmute yourself.
Does he need help unmuting? Do you know
I don't know.
his number?
Marty, will you text me your telephone number? And in the meantime, I am going to call on Jim Nagels. I'm unmuting you now.
Hello, everyone.
Hi, Jim.
How are you?
Good. How are you?
I'm doing pretty well. Got a couple of questions. Lately, I've seen something from one of my information sources, newspaper, TV, internet, about a practice of eviction for abandonment of the property. And I understand that doesn't have anything to do with rent or what. How does that work?
That's a great question, Jim. We have, I think, a pretty strict abandonment statute, and also a pretty confusing one. So under our abandonment statute, if a landlord puts something in the lease, if he puts it in the lease, he can require, or she can require a tenant to notify the landlord if that tenant is going to be absent from the property for more than 7 days, which, just Christie's opinion here, is a very short period of time. If the landlord believes that a tenant has abandoned the home, the landlord under the statute can give them post a notice on their door saying, hey, I believe you abandoned this home. If you haven't abandoned, and if they haven't abandoned it, they must send something in writing telling the landlord that, again, within 7 days. So very short timelines. Here in Richmond, one of the attorneys at Central Virginia Legal Aid had, and we almost never see these cases, but earlier this week, had 3 different clients come to him who had been sheltering in place in their rented, and were not living together, 3 separate tenants who had received these abandonment notices. He was able to get it cleared up with the landlords, but it really shines some light, I think, on how this statute can be misused and on how short a period of time 7 days is, and how easy it might be for someone, a tenant, to be at home, sick, and never even know that they received a notice, and then have their landlord come to evict them. So it is, in fact, one of the things that this COVID-19 crisis has brought to my attention as something that I would hope the legislature would consider changing in either a special session or the 2021 session.
So, and from my perspective, I think with courts closed to non-emergency hearings, I think we are in a golden age of creative/illegal eviction tactics by unscrupulous landlords. And so we're going to see all kinds of things. You know, we've already seen the kind of the standard either changing locks or cutting off utilities, which is, you know, everyone understands, every landlord understands is illegal without court process. We've also seen the extended stay motels kicking people out, locking people out. It's easy for them. They can just change the electronic codes that their key card uses. And so we've seen a lot of that, and then other more creative things like this abandonment or whatever. But I really think, you know, certainly the Eviction Legal Helpline has seen a lot more either threatened or actually carried out illegal evictions during this judicial emergency. I don't expect that to end anytime soon.
Can I have a couple more questions, short ones?
Jim, do you mind? Well, I'll leave that up to the participant.
Well, I was going to let you, Tony, you're our Vanna White, so you go ahead.
Okay. Jim, do you mind if we come right back to you? I want to make an announcement for the people that are on the phone. I tried to unmute everyone so that you guys could participate in the Q&A session. However, it was providing a lot of background noise. So I'm going to give you my cell phone number and you can text me if you have a question. And that number is 804-658-9969. Again, the number is 804-658-9969. And I'm going to unmute Marty. So since I had not done it correctly earlier. Marty, are you there?
Yeah, hey, Tony, can you hear me?
I can.
Okay, great. So I'm Marty Regbrand. I'm the Director of Litigation at Central Virginia Legal Aid Society. And I have like 4 quick comments and then a question for Christie. So just to comment 1, so just to follow up on the misuse of the abandonment statute by landlords. The abandonment statute is actually a weird form of, quote, tenant protection, because if the landlord actually drives by and looks in and sees, oh my God, the curtains are down, there's no blinds, no furniture in there, the tenant's left, it's really sort of a form of tenant protection just to make sure that the tenant really is gone, to require the landlord to give that 7-day notice to say, hey, I think you're gone. If that's not correct, let me know within 7 days. And the landlords are using this statute that's sort of intended to protect tenants as an end around against the fact that they can't get a case heard in general district court for non-payment of rent from now through, May the 17th, and possibly really not until mid-June. So, I mean, it's absolutely despicable tactic, and tenants should be told repeatedly over and over they don't have to move just because the landlord says so, whether that's orally or in writing. Number 2, to follow up on what Phil said about tenants who are living in motels, that's a huge problem. And again, the message to get out is that if a tenant is in a motel less than 90 days, they are not legally considered a tenant, not legally entitled to the protections of tenants, except the motel owner has to give them a 5-day non-payment notice before on the day 6 or subsequent, the motel owner can evict without going to court. But if they are there more than 90 days, they are legally a tenant. They are entitled to all of the protections of tenants, and the landlord must take them to court. And that distinction is not getting out there, and we really need to spread that word that people who have been in motels for 90 days, they're not just motel occupants, they're tenants. The third, and this goes back to the what RRHA may be doing, and there was some mention about something that RRHA is requiring by May 1. That might just possibly be referring to the no questions asked repayment agreements that RRHA announced back in January. And we met with RRHA back earlier this month, and we received a absolute assurance. I don't know that we have it in writing yet, but certainly an absolute assurance that the deadline for those no questions asked repayment agreements is extended to through July 31st. So if people owe rent to RRHA, they have through July 31st to contact RRHA. Of course, these days it's difficult because they are also closed and working remotely, but they have through July 31st to contact RRHA, sign one of these agreements that basically says, this is how much we think you owe, and you have to pay your ongoing rent as due, and the repayment is 10% of their adjusted gross income, and that it'll never be more than that, even if their income goes up. And it could very well go down if their income goes down. And there's no time limit on how long those repayment agreements could be. So it could be years to pay off whatever they owe RRHA if all they're paying is an additional 10% per month of their adjusted monthly income. The fourth thing had to do with the eviction moratorium that applies to covered properties in covered that are participating in covered federal housing programs. If you read the statute just the way it is written, it applies to properties that are participating in covered federal housing programs. And the Housing Choice Voucher Program is specifically mentioned as a covered federal housing program. And so we interpret the language to mean that if you've got, let's say, a multifamily building with, let's say, 4 units, and only one of them is participating in the Housing Choice Voucher Program, the other 3 units are occupied by tenants who are not renting with a voucher, we believe a clear reading of the statute is the entire building is covered, not just that one Housing Choice Voucher tenant unit. Unfortunately, as you, to no great surprise, the Department of Housing and Urban Development has come out with a guidance or an opinion that differs with that and says, oh, no, it just applies to the covered unit in the covered property, not to all of the units in the covered properties. We disagree, and I think there'll be litigation on that. But the point is that the people who are living in properties where they're not renting with a voucher, but other people in that same property are renting with a voucher, they should not despair. They may very well be subject to the same moratorium. They certainly should contact legal aid about that and let us litigate it. And then the question I had for Christie is this, and you didn't mention, you haven't gotten to this yet, and you probably will want to get to it, is the governor's protection that was added to House Bill, I think it's 340, where if you are a tenant or a homeowner who is affected by COVID-19 during the period of the state of emergency, which of course, as we know, began March 12 and goes through, well, now June 10, unless it's lengthened or shortened by the governor, then you can, and you're sued for non-payment of rent, you can get a 60-day postponement of your case just by coming to court and giving proof. But the way I read the statute, and Christie, this is what I wanted to question on, was it says affected by means a loss of income from a public or private source, so that the affected party must request a postponement by providing written proof to a court that he is not currently receiving wages or payments from a public or private source as a result of the emergency.
Right.
So does that mean that I have to essentially be at zero income?
I don't think so. And here's
okay.
What the governor did, and then the General Assembly approved last Wednesday, was an amendment to House Bill 340, which deals with providing that 60-day extension of an unlawful detainer or eviction hearing, or a 30-day stay of a foreclosure to employees who of the federal government after they have been furloughed, after a government shutdown. When the second enactment clause, which is what it's called technically, was added to the bill as an amendment last week, what it did was it said, hey, the provisions up in the other original part of the bill that relate to continuances of unlawful detainers and foreclosure stays also apply in the case of income loss due to COVID-19. I think reading it as a whole, I do not interpret it as requiring that strict I know you're worried about people who get their stimulus check, people who get unemployment income. I think if you have suffered a loss of income because your business closed, or you worked for a business that closed, or the person who paid your child support lost income and lost a job because of COVID-19, you are entitled to that 60-day continuance. That's how I read that. And I know that, I mean, that's my understanding.
Sorry, I had to mute him based on some background noise that was coming. That was interfering, Christie, with your comments. So I'm going to unmute again, but Marty, I also need to be mindful of our time, and we have several other people with their hands raised.
Right. Okay. Just this is real quick. So the argument is that if it meant you're at zero income, then the second enactment clause would have been something like stating that he is not currently receiving any wages or payments.
Right. And Marty, we will,
lack of the word.
yes.
Yeah.
And we can go over
got
this in further detail on Thursday at our task force meeting.
Got it. Okay, I'll shut up. Bye.
I'm gonna, and Jim, I know you're still holding, but I'm going to unmute Alexander. I'm sorry, I hope I don't mess up your last name, but Rydell? Alexander, are you there?
I just
Yep,
unmuted
I'm here.
him. Yeah.
Okay, so I just had a very brief follow-up to what Phil Storey was talking about, asking about using unlawful exclusions to deal with issues where the landlord's just been trying to use self-help eviction, change the locks, cut off the power, things like that. Has anyone had a case like that, and have they got any pushback for trying to get that classified as an emergency so that the hearing could be heard right away? Because I think everyone would agree that that is an emergency, especially with sheltering in place.
And Phil, you may know more about this than I do. The only person, Alex, that I've heard who has had those types of cases and filed those petitions is Palmer Heenan in Richmond at Legal Aid working with Marty. My understanding from following up with Palmer is that he was able to resolve those without actually having a hearing, but that the court had scheduled hearings. So they were recognizing the emergency nature. I don't know if Phil has anything else.
I think I heard back from somebody in maybe Winchester, but from a legal aid attorney at Blue Ridge Legal Services, that she had also had scheduled an emergency hearing on that.
Thank you. Bob Stinthorn, I've unmuted you.
Thank you. Folks, has anybody got any guidance or success using force majeure as a reason to get some of these evictions delayed? Because when the wave crests, we're not going to have new housing available for people that are being put out on the streets.
I haven't looked at that.
I haven't either.
Yeah, but that's a good point.
A lot of the, in other states, they're using it as contract principles as a way to try to delay some of these implications. And if we fail under landlord tenant, it's still a contract. And it's kind of putting I'm going to be homeless if I'm evicted in front of the judge.
Mm-hmm. I think that's a great suggestion. We are going to be very happy to hear all strategies from people both here within Virginia and our similar folks, legal aid attorneys, and other housing advocates across the country. I think we're all going to have to be creative, and I certainly made a note of that, Bob. So thanks.
Yeah, I've had folks interested in whether or not they can use that defensively to their liability for rent, which I really doubt. Folks, college students, a lot of college students obviously are stuck with paying rent in a place that they no longer live. So, but that using that as to avoid actual eviction seems much more plausible to me.
Yeah.
And Jim Nagels, I'm unmuting you, I hope. Yes, you're now unmuted.
One question. I didn't notice whether one federal program was justification for the application of some of the new laws covering this situation. There's something called the Low-Income Housing Tax Credit program that basically gives credits to people who build housing for low-income people. It's one of the things they can write off on their the taxes. Has anybody heard anything about whether that whether the new law applies to that or what?
It does.
Yeah.
It
does?
Yeah,
Good.
the federal law, the federal eviction moratorium does apply to the LIHTC properties.
All right. Thank you, Christie.
And thank you, Jim, for your patience. I appreciate that. Did anybody else have any questions? Lynn Bennett, I'm going to unmute you. And you have the best screensaver ever.
You like that?
I do.
I'm all zoomed out, and you'll have to deal with Jay. But one of the, and I'll talk about this offline here with you all, because of the session that's coming up provides a good opportunity to enact some changes that are beyond COVID-19, but that certainly where COVID-19 provides us the impetus to get our legislators to accept some of these changes. But one of the marketing points, and of course I represent, as VPLC does, consumers at all levels, is you have a moratorium on evictions, but you have a lot of single-family homes that are owned by people that can't themselves pay their mortgage. And of course, the foreclosures, if it's federally backed or CARES Act protected, are protected. But we're, this isn't going to end anytime soon, and life's not going to get back to normal on June 11th. Are there efforts made, particularly when in Richmond we're going to be trying to convince, I don't know, I won't name names, we're trying to convince some particular state senators, and but maybe a pitch that provides relief to owners of these properties, and other than tax relief, who are subject to the eviction bar, both CARES Act and the maybe even self.
So, are you talking about the essentially rent relief for some of the landlords, the owners of both the single-family homes and the multifamily?
Right. So, for example, with Mark Warner and the efforts on credit reporting, right? Our pitch there, just by analogy, is to say, look, the free market is going to be hurt if you allow inaccurate reporting. People who really are good bill payers are screwed uniquely here. So you should, for the sake of a coherent market, not because of patronizing empathy that really should be the reason. So the same thing with respect to legislators. I mean, if we go in and we say, the tenants are really in need right here, then we're subject to the argument from the realtors and from others that homeowners or that the actual commercial entities that are renting are getting hurt. And so coming up with a strategy, whether it's putting together packets for those folks or efforts for them, particularly the single family owners, I mean, the service member that transferred and rented their house, that kind of thing.
Right.
I don't know of anyone that's doing that, and I don't really know that it's our charge, VPLC's charge, but
I think it is to a certain extent. It has always been, since I've been doing this housing work, I know that I've always tried to find common ground with people who, with the housing providers, with the landlords. But right now, the most urgent need, I think, is just for this cash assistance. And so VPLC convened a call, I think it was 2 weeks ago now, with about 45 other housing stakeholders, a number of whom were either nonprofit housing providers, folks who provided financing for nonprofit housing developers, or the heads of private landlord associations. And we focused that call on how would we want what were some of the essential elements of a rent relief program. And I actually, Len, just today, my team and I put together a letter that we'll be sending to the Virginia congressional delegation, specifically asking, we're specifically supporting the National Low Income Housing Coalition's ask for $100 billion in federal funding for a national residential rent relief fund. And then we go into some of the things that we want to see in that rent relief program that pretty much the stakeholders on that call agreed to. I'm sending that letter out in the hopes to get everybody on board with it who was on that call. So that's sort of the immediate use of, I think, what you're talking about. I definitely think we need to keep thinking along those lines and thinking about how some of the changes that we know are so important for tenants can also benefit the housing provider by increasing the likelihood that rent will continue to be paid. So yeah, I absolutely agree with you on that.
Great. And I want to interject and just be mindful of everyone's time, because we try to keep this session to about an hour. We have one last question. And then if anybody has questions after Willie Hilliard, and I'm going to unmute you, Willie. But if you have questions, Christie and Phil can stay on after we wrap up for any additional questions, and I'll put their contact information in the chat as well. But Willie, you're up.
Yes, hi, how y'all doing? Listen, this is not so much a question as I would just run this down. I do have a picture of the flyer that's been put on the doors in the RHA properties, and this one actually came from a person in Gilpin. And it says, rent is due, repayment agreements offered. What this means, if you owe any money to RRHH, sign a no questions asked repayment agreement to return to good standing and avoid legal action. Starting February 12th through May 1st, 2020, any resident who owes RRHA money can ask for a repayment agreement that includes any money owed to RRAH for any reason, does not require a down payment, has monthly payments based on your income. Repayment agreements will only be accepted until May 1st, 2020. Normal lease enforcement will start after May 1st, 2020. There will be no repayment agreements with these special terms after this time. So that's
when was that distributed? Was that just recently?
Yes, I would assume within this week.
Wow.
That's super problematic.
Yes.
So thank you for bringing that to our attention, because Marty, as Marty said earlier, and I don't know if he's going to chime in again, but there was an agreement, or at least I thought he said that there's an agreement. I know there were discussions about reaching an agreement that no questions asked payment plan would continue to be offered until July 31st. And we know under the CARES Act that they cannot take any eviction action based on non-payment until after July 25th. So thank you for sharing that.
Okay, I'm going to, in the sake of, and thank you, Willie, thank you. For the sake of being mindful of everybody else's time, Phil, I'll turn it back over to you.
Actually, I think Christie was going to make this.
Go ahead, Christie, sorry.
Oh, okay, well, yes, I will then. So first of all, thank you for spending an hour with us. Thank you all for asking questions, and Phil and I will hang around virtually if anybody has other questions or things they want to discuss. We are happy to just have you here and hearing about the helpline and hearing about the laws. And one way that's not on here that you can help is by letting people know that we exist, letting tenants in your communities who are worried about getting evicted know that the eviction legal helpline is available for them, and give them that number, 833-NO-EVICT. And that in and of itself, doing some outreach for us just in your day-to-day life and interactions with other community members is something we greatly appreciate. If you want to help even more, there are volunteer opportunities for you at the Eviction Helpline. Phil is wonderfully well organized, has wonderful training modules that are available. And you can volunteer if you are not a lawyer to do the intake work and get people's initial information. And if you are a lawyer and would like to answer questions and give advice to these folks on the helpline, we would be extremely grateful for that. And as Tony has put up here, number 2, just so you know, a $75 donation to Virginia Property Law Center can help one person get legal advice from the helpline. I want to point out that they may get way more than legal advice, because when Phil finds a case that has a defense, he packages that case up and sends it off to the local legal aid, and that may be the difference between that person getting evicted and that person staying stably housed.
And of course, Marty Wegbright, who has chimed in a little bit, has been on the receiving end of many of those, and he has kept many tenants who called the helpline, has kept them in their homes successfully.
And finally, just so you know, if you go to our website, there's a special little button you can press that says COVID-19. And we have many resources related to the current public health crisis, especially under our